Hello, my name is Julie Thompson, and today I will be talking to you about students' freedom of expression, what teachers need to know about the law. All of the laws relating to freedom of speech involve use of the First Amendment. Freedom of speech is a constitutional right provided in the First Amendment. Before 1969, schools had the power to create rules that limited students' freedom of expression. Because students were legal minors, administrators believed that not all the First Amendment rights applied as they do for adults. When the rules were challenged in court, the justices used a reasonableness test. If the rule seemed reasonable, the courts upheld the school's rule. The first major landmark Supreme Court decision to give students rights towards freedom of speech occurred in the case Tinker versus Des Moines School District. It was in 1969. Several students planned to wear black armbands to school to protest U.S. involvement in the Vietnam War and mourn the dead on all sides. School officials learned of the impending protest and quickly adopted a no armband rule. The students nonetheless wore the armbands to school, and school officials suspended them for violating school policy. The students sued, claiming violation of their First Amendment rights. The major issue the Supreme Court justices had to deal with was whether school officials can censor nonviolent student speech without showing that the speech will cause a material and substantial disruption of school educational activities or collide with the rights of others. By a 7-2 vote, the Supreme Court held that school officials cannot censor student speech unless school officials reasonably forecast that the speech will cause a material and substantial disruption of school activities or collide with the rights of others. Mere apprehension of disturbance or an offense given is not enough. Students do not lose their constitutional rights at the schoolhouse door. School officials' duties to provide a safe learning environment must be balanced against students' free expression rights. School officials may not censor student speech because of an undifferentiated fear or apprehension. They must reasonably forecast that the student's speech will cause a substantial disruption or invade the rights of others. In the Tinker case, the record does not demonstrate any facts which reasonably may have led school authorities to forecast substantial disruption or of material interference with school activities, and no disturbances or disorders on the school premises in fact occurred. Students do have free speech. Justice Fortas' famous quote in the Tinker decision is that students and teachers continue their constitutional rights inside schoolhouse walls. This case really opened up a lot more freedom for students than they experienced prior to 1969. The next Supreme Court case is Bethel School District v. Frazier in 1986. A public high school student, Matthew Frazier, delivered a nominating speech on behalf of another student at a student assembly. The speech contained elaborate and immature sexual innuendo. The school suspended the student for violating the school's no disruption rule, which prohibited obscene, profane language. The student contended that the suspension violated his First Amendment rights because his speech caused no disruption of school activities within the meaning of Tinker. In a 7-2 decision, the Supreme Court held that school officials may prohibit student speech before a student assembly that is vulgar, lewd, and plainly offensive. Public school officials have a responsibility to inculcate values into students. Surely it is a highly appropriate function of public school education to prohibit the use of vulgar and offensive terms in public discourse. The vulgar sexual allusions of the student in this case differ markedly from the pure political message of the black armband case of Tinker. School officials were not censoring speech based on viewpoint. Rather, they were punishing the student for using vulgar and lewd terms at a student assembly. Vulgarity is not free speech for students in school. The next Supreme Court case, to further clarify the rule established in Tinker, is Hazelwood versus Kuhlmeier, 1988. In this case, students produced a school newspaper as part of their journalism class. One issue was to include student-written articles about teen pregnancy and the impact of divorce on children. The principal objected to the stories, believing they were inappropriate for the younger students and unfair to the pregnant students who might be identified from the text of the article. He also believed that the parents of the students quoted in the divorce article should have been given an opportunity to respond. He deleted the articles from the school newspaper. 3 students sued, claiming a violation of their First Amendment rights under the Tinker standard. By a 5-3 vote, the U.S. Supreme Court held that school officials can censor school-sponsored student publications when they have purposes reasonably related to legitimate educational concerns. There is a fundamental difference between private student speech and student speech that occurs in school-sponsored activities. Educators have greater authority to control school-sponsored student speech because the public might reasonably believe that the speech bears the imprimatur of the school. Educators do not offend the First Amendment by exercising editorial control over the style and content of student speech in school-sponsored expressive activities, so long as their actions are reasonably related to legitimate pedagogical concerns. A publication created as part of a class is clearly school-sponsored and a part of the curriculum. The school never adopted a policy whereby the publication simply became a public forum open to any and all views. The school administration thus properly acted as editor of the newspaper. The final case, involving student free speech up until this point, is Morse v. Frederick. As you can see from the picture, a group of students created a large banner with the words "Bong Hits for Jesus" on it. This was during the Olympic torch run in Alaska. As the principal looked out and saw the "Bong Hits for Jesus" banner, she believed that it advocated illegal drug use. Because the students had gone outside of school to watch the Olympic torch rally, she considered it a school-sponsored event and would not allow that sign. So she suspended one of the students, Joseph Frederick, for violating the school's anti-drug policy. Frederick and his parents went to see a lawyer, and they sued Principal Morse and the school board for violating their son's rights. Initially, the U.S. District Court ruled in favor of the principal, but the Court of Appeals ruled in favor of the student, Frederick. So the principal appealed to the Supreme Court. In the decision, they said that school authorities do not violate the First Amendment when they stop students from expressing views that may be interpreted as promoting illegal drug use, thus giving schools additional rights to regulate students' speech. So in conclusion, students may exercise their rights to freedom of speech in schools as long as doing so does not cause a material or substantial disruption in school, the Tinker test. Schools may punish students from using vulgar or lewd language in school assemblies, the Bethel case. Schools may censor anything in their publications or productions for legitimate educational concerns, the Hazelwood case. And schools may punish students for promoting illegal drug use on or off campus. I hope you will be able to put this information to good use in your daily practice. Thank you.